Good afternoon, everybody, and thank you for joining us for another webinar in Conn Carey's OSHA webinar series. I'm always excited to talk to you all about OSHA issues. I'm particularly excited today because I'm joined by a couple of colleagues that I'm very excited to co-present with today. One, my partner Andrew Sommer, who heads our California practice, and always excited to be joined by Andrew, but today I'm particularly excited to be joined by Megan Shaked, our brand new associate out in California, who has started just this week, and we've thrown right into the fire by asking her to join us on one of our webinars. Today's program is going to be all about Cal OSHA. Really interesting Cal OSHA issues that California employers must track and, more importantly, must understand. And we're going to do our best today to keep you informed so that you can track these interesting issues, and better yet, try to present them in a way that you can all understand what's happening out there in California, which is really a special place when it comes to the regulatory landscape, and Cal OSHA no exception. The faceless voice that you're hearing right now is Eric Conn. I'm one of the founding partners of Conn Carey, and I chair the firm's national OSHA Workplace Safety Practice Group. For the last 19 years, my practice has focused essentially exclusively on workplace safety and health issues, representing employers in inspections, investigations, and enforcement actions involving OSHA and just about every state OSH plan out there. I've yet to do anything in Alaska, but I've done, unfortunately for you all, I've done an awful lot in California that has been one of the state agencies that has kept us the busiest, and why it is that we're growing our California practice and our California offices with the addition of Megan this week. I'm very pleased to be joined today by the head of our California practice, Andrew Sommer, my partner for quite a few years now. Andrew is a veteran labor and employment attorney and Cal OSHA attorney. He represents employers in litigation in federal and state court involving all matters related to the employer-employee relationship, and a whole lot lately dealing with Cal OSHA, inspections, investigations, enforcement actions, and litigation against the California Division of Occupational Safety and Health. And as I mentioned, particularly pleased to be joined by Megan Shaked today, our brand new associate in our San Francisco office. Megan is a seasoned employment litigator, first chairing trials out there in California involving all manner of employment litigation, as well as bringing some experience on the Cal OSHA front to expand our bench to help represent employers in their dealings with Cal OSHA. We have a very full agenda today, and it's fortunate that because I'm here on the East Coast and you all are out there on the West Coast, that really means 1 hour equals 3 hours, something like that. I'm not strong with different time zones, but we will have plenty of time to get all this ground covered. We'll try and get this done in about an hour. We're going to cover a little bit about Cal OSHA enforcement data and trends, and a couple of really major developments at Cal OSHA over really the last year and a half, and some things that we anticipate will be breaking developments either over the course of the rest of this year or early next year. And those things include a rise in civil penalty authority and usage of that civil penalty authority by Cal OSHA, expanding the scope of what is a repeat violation in California and how that's been used by the agency. The status of the electronic record-keeping rule, one of the really great tugs of war between federal OSHA and the state OSH plans. What is going on with submission of electronic injury data in California and the rest of the country? And then some specific Cal OSHA rules or rule makings. The workplace violence rule, which is in place now in the healthcare industry, as well as a proposed rule for workplace violence hazards in general industry. Hotel housekeeper ergonomic standard to address musculoskeletal risk factors in the hotel housekeeping or hospitality housekeeping industry. an indoor heat illness prevention proposed rule to go hand in hand with the outdoor heat illness prevention rule that Cal OSHA has been enforcing for several years now. And then finally, as always interesting and sort of fits in every webinar we seem to conduct these days, is what's going on with marijuana. As California has expanded what is lawful in terms of development, sale, and consumption of marijuana in California, what does that mean from a workplace safety and health standpoint, and can we expect any regulatory changes that might affect those that work around or with cannabis and marijuana? So we got a lot of ground to cover. We're going to try and hit these points quickly. If you have questions, we have muted the audio lines, but there is a chat function. Please type in your questions in the bottom left corner of the screen, and we will address those as it makes sense in the flow of the program. And then, of course, if you have any questions after today, please don't hesitate to reach out. You will learn, if you don't know us already, you will learn by the end of this program that we're big nerds, safety and health nerds. We love talking about this stuff and would love to field any questions you have. And with that, with the agenda here in front of us, I am very pleased to hand things over to Megan to talk about the first topic on our agenda.
Great. Thank you, Eric. I'm happy to be here joining Eric and Andrew and you all. Diving right in, as Eric said, to the Cal OSHA enforcement trends. There was basically a 5-year report that was presented to the California legislature by a labor enforcement task force, gathering data from 2012 to 2016. And as you take a minute to digest this next slide, I just wanted to point out a couple of rows, starting with the second one, the percentage businesses out of compliance based on all of the businesses inspected, which the numbers are given in the first line. The percentage businesses out of compliance, we have the 2014, 15, and 16 numbers, and these numbers are quite staggering. We see an increase from 86%, already quite a high number, to 89, and then 93% in 2016. And the takeaway here, other than realizing how important continued education is on this, is that these numbers may be more a reflection of how Cal OSHA is doing business rather than a sign of how the employers themselves are doing business. This is indicating that when an inspection is done, they're looking for violations, and more likely than not, they're not going to leave until they find one. So those numbers are getting higher, and since we only have data until 2016, it remains to be seen if these numbers will continue to increase. Another line we wanted to point out in particular is the per violation penalty, which has nearly doubled from 2014 to 2016. So if you see the number of violations in the fourth line as compared to the initial assessment amounts in the final line, you see those penalty amounts per violation are increasing, showing that the penalties are being assessed closer to the maximum allowable penalties. Now, one potential explanation for why there's been these increases and this trend upwards is pressure from the federal agencies to the local agencies, including California, for not using the serious, willful, or repeat violations, these violations that kind of reflect on the employer's state of mind and involve intentional and repeat violations. And there's thoughts of whether violations that may have once been classified as a general violation may now be more likely to be classified as serious violations, which would increase the assessment amounts and the classification of the violations. Another note is looking towards the future, and Eric and Andrew will speak about this as well, is that since there have been some policy changes since 2016, it again remains to be seen how these numbers will change going forward, but it would not surprise us, and stay tuned for next year's seminar if these numbers will continue to increase.
Thanks, Megan. I think that is a good transition into the next topic here, which is Cal OSHA civil penalties expected to skyrocket. And just looking back at that, this is one of the more remarkable things. That line there about total number of violations between 2014 and 2016 are essentially the same, right? 2,779 violations alleged in 14, 2,736 alleged in 16, but then the penalty amounts associated with almost an identical number of violations almost doubling, and that's up to 2016. So just wait to see what happens with the data in 17 and 18 based on what we're going to talk about here next. Back in 2015, in the wake of one of the great debates and on the brink of a government shutdown. I think we're now 4 or 5 government shutdowns removed from this particular battle. But back in 2015, President Obama was in office with a Republican Congress. We were coming up against one of the debt ceilings, and there was a big risk of a government shutdown. And behind the scenes, to avoid that government shutdown, John Boehner, then Speaker of the House, one of his very last acts on his way out the door, brokered this deal with the Obama administration to avoid the shutdown. They agreed, the Republicans in Congress agreed to implement a provision in the Bipartisan Budget Act to keep the government operating, a provision called the Civil Monetary Penalties Inflation Adjustment Act. And what this did was it required federal agencies to increase maximum civil penalties to catch up with the cost of living adjustments since the last time that agency's civil penalties were increased. And so at the time, there had been, from an OSHA standpoint, federal OSHA standpoint, the penalties had not been raised since 1990. Most of the other federal agencies, enforcement agencies, either have an automatically updating penalty mechanism like EPA does, and others just have periodically raised their penalties over time. Fed OSHA has not touched their penalty authority since 1990. Since 1990 up to 2015, when this Inflation Adjustment Act was signed into law, there had been a 78% increase in the Consumer Price Index. So that meant that Fed OSHA had to do this one-time increase of 78% to its civil penalty authority. And then this law also mandated annual increases as CPI continues to creep up. There'd be an automatic annual increase in the agency's penalty authority. The reason why I'm talking about Fed OSHA here in this context is because Fed OSHA notified all of the state plans, Cal OSHA included, that Fed OSHA expected the state plans to adopt this same policy, that as Fed OSHA increased its civil penalties by 80%, that they were expecting the state plans to do the same. Under the theory that Fed OSHA approves the state plans to operate, provided that they are at least as effective. And from Fed OSHA's standpoint, at least back in 2015, being at least as effective meant having the same enforcement teeth that Fed OSHA has. So Fed OSHA notified the states that they're expected to increase their penalties as well, but also at the time, not only to increase the max penalty authority, but also to adopt Fed OSHA's penalty policies, things like available penalty reductions, and perhaps also some pressure at that time, policies around repeat violations, which is one of the reasons, Andrew's going to be talking about Cal OSHA's new repeat violation rule as well. So the effect of this rule on Fed OSHA was to increase civil penalties related to other than serious and serious violations, other than serious being the equivalent of I think a general is what it's called in California, general and serious violations that were capped out at $7,000 per violation since 1990. increased to about 13,000. This is the current figure with a couple of years now of annual automatic updates. So almost 13,000 total for those. But the willful and repeat violations jumped from 70,000 per violation as a maximum up to more than 125,000 per violation. So a very significant increase on that willful and repeat front. Andrew will now talk about what effect that's had here in California.
So in California, we traditionally have had penalty amounts that have been kind of reasonably high, but then when suddenly the Fed OSHA penalty amounts had soared based on the developments that Eric was discussing, we saw Cal OSHA actually lagging behind the Fed penalty provisions. And so the Cal OSHA penalties for general were a max of $7,000, and they were a max of $70,000 for willful and repeat violations. In light of the federal developments and pressure from the feds, Cal OSHA has recently adjusted those penalty amounts. And so serious violations have always been higher than the feds, or at least in recent years, at $25,000. The failure to abate at $25,000 a day has been on the higher end. But we're seeing a major spike in general and willful and repeat violations based on this development. And I think we will see over the coming years higher assessed penalties overall, and those should be reflected in future statistics by Cal OSHA. And just to note here, there are adjustments that can be made by Cal OSHA in the penalty calculations. There's a number of different variables that are considered: the extent of the injury, the record, the history of violations by the company, abatement credits that can be provided. All of those factor into the equation. But one important note is that if it's a serious accident-related violation, that is a type of violation that for which there can be no reduction in the penalty except as to the employer size if it's a small employer. But I wanted to move into the next issue, which is repeat violations. And looking at both the increase in penalties under Cal OSHA's scheme as well as the new repeat violation rule in California, there is the potential for more aggressive enforcement by Cal OSHA in terms of the classification and the penalties being assessed. There was a time when our repeat rule in California was pretty favorable and much better than the feds. And we were saying that the standard was essentially, the historical standard is that you look at, for fixed establishments where you have a set place of business, such as a factory, that in those situations you'd only be looking at violations at the same location to determine whether there is a basis for repeat violation. And basically a repeat violation in a nutshell is that you have a violation of a Cal OSHA standard that reaches a final determination at, for example, a location in California, and then you have a similar or the same violation a number of years later. And then the question is that within the window for Cal OSHA to then assess a repeat violation, which has very broad ramifications. It results in an increase, a substantial increase in the penalty amount, and then can present all sorts of issues. If, for example, if you're a contractor and you have to bid on contracts and have to disclose that. So essentially, the old Cal OSHA rule focused on the one fixed establishment and determining whether there's a basis for a repeat violation. If the business had multiple establishments where it did business, such as contractors that would go out to individual sites, you'd be looking at the region where the violation occurred as a basis for determining whether there's a repeat. And the look back period was 3 years under the old rule. So you're looking at whether it was essentially the same violation that occurred within a 3-year period and occurred at the same establishment where it's a fixed establishment business. And so that was fairly confined in scope and provided less opportunity for repeat violation. But that has changed, and under the new rule, bowing to pressure from Fed OSHA to maintain a plan that's at least as effective as Fed OSHA, which is a requirement for maintaining the state plan, that California took the standard and modified it so it conforms essentially to the Fed OSHA standard. And so now the difference is that in assessing a repeat violation, you're looking at violations occurring anywhere in the state. So if you have 5 different facilities in California and you have a citation, you need to be looking at whether there's a potential for one of your sister facilities to cause you to be subject to a repeat violation. And the other significant change is you're no longer looking at the same standard being cited again as forming a repeat violation, but it just has to be a substantially similar standard based on similar types of hazards. And then the other significant change is that the look-back period under the new rule is 5 years. So in short, you're looking at whether there was the same or substantially similar violation against the employer anywhere in California within 5 years from when the prior or the first citation took effect. And for the purpose of calculating that 5 years, you look at when the first citation was operable as a matter of law, meaning that the period for appeal has passed and there has been no appeal, or if there has been appeal, you look at when there was a final determination on that matter. It could be by the matter going to a hearing or a settlement in that case that results in an order. So this new repeat violation rule took effect on January 1st of 2017, and so we're seeing the ramifications now. It's taking a while to see these repeat violations surface in greater context. So what's the takeaway here? If you have multiple facilities in California, any time that you broach a settlement with Cal OSHA, or you just simply evaluate the citations and what course you want to take, you need to look at the nature of the citations and how that could affect your sister businesses within the state. So if you have other facilities, is the citation that's issued something that's likely to reoccur at your other facilities? And if you have a citation that is on the books, whether it be that you didn't appeal or you worked out a settlement or otherwise, you want to look at your operations to make sure that you've addressed this type of violation throughout the company in California to make sure that you can minimize any potential for repeat violation down the line. And so, when we litigate these citations, when we take them on appeal and we're engaging in settlement negotiations, we're always looking at how we can address the citations in a way that's going to minimize exposure for repeat violations. So it could be changing the type of violation, rewriting the violation to a standard or amending it to a standard that's less likely to resurface with the company in the future from a Cal OSHA inspection. Or we might want to amend the standard to a category that is unlikely to reoccur. So for example, if you are not in the construction industry, but there was some construction done by a third party that gave rise to a violation, that might be a standard you would want to accept as an amendment or otherwise, because it's not something that's kind of germane to your industry and is likely to reoccur. And then sometimes we'll rewrite the violation language to make it very specific or very general in a way that you could show that a future situation involving a similar standard was different, that involved a different set of facts, a different set of hazards than was encountered in this matter. All right, so now I'm going to turn it over to Eric to talk about the electronic recording rule.
Thanks, Andrew. This is one of my favorite topics of the last couple of years is OSHA's electronic record-keeping rule. The actual formal name of this is the Improved Tracking of Workplace Injuries and Illnesses, but this is one of these where the misnomers we apply to things in Washington, D.C. The electronic record-keeping is what it's known as more colloquially. And this is a rule that FedOSHA adopted several years ago, went into effect with the first year of data submissions last year in 2017. Employers of a certain size or in a certain industry were required to submit some of their injury and illness record-keeping data into an electronic portal that FedOSHA had built by an outside IT company. And here's just the general makeup of this rule, that if you have an establishment, this is not a company-wide measure, but an establishment, a workplace with 250 or more workers, then regardless of what industry you're in, by the original rule, you were required to submit electronically to OSHA your data from your 300 log, your injury and illness record-keeping log, the corresponding 301 incident reports for each injury reflected on those logs, and the 300A annual summary that identifies sort of rolls up at a higher level to number of injuries that require days away from work, the number of injuries that require job restriction, the number of recordable injuries, et cetera, without the level of detail of the 300 log and the 301 report. For smaller employers with establishments, workplaces with between 20 and 249 employees in certain high-hazard industries, and I put those quotes in there. Those are supposed to be obnoxious finger quotes to reflect another misnomer. OSHA basically took the average DART rate, the average recordable injury rate for all industries across the country, and said if you were essentially average or worse, that is a high hazard industry. So it's really average hazard industries are covered by this rule at the 20 to 249 employee level. And this is not your individual injury rate. This is your industry's average injury rate would trigger whether you're covered by the rule. And for those employers in the 20 to 249 in certain high hazard industries, those employers were required to submit only their 300A annual summaries. We're now at July 10th, 2018. July 1st, 2018, a week and a half ago, was the second deadline for data submissions under this rule. FedOSHA announced that employers in that larger category that were supposed to be submitting the 300 logs, the 301 incident reports, and the annual summary data only needed to submit the annual summary data this year, and we're all expecting that there's going to be a rulemaking that makes that a permanent change. So I'm talking about this FedOSHA rule because when FedOSHA promulgated that rule, they mandated, as they have the right to do under the OSH Act and with their authority to approve and oversee state OSH plans, FedOSHA mandated that all state plans adopt this electronic record-keeping rule. And FedOSHA said when it adopted the electronic record-keeping rule that, hey, state plans, you've got to get this done, I believe they said in 6 months. So this was back in, I think, 2015. They adopted the rule and said, states, get on board, get this done in the next 6 months, and we're going to have as our initial deadline the middle of 2017 for the first data submission, which they ended up pushing out to the end of December 2017 for the first data submission. Most of the state plans, and there's more than 20 state plans that operate around the country, most of them adopted the rule, basically a Me Too rule, exactly what FedOSHA said is the new rule in Virginia and all these other state plans. But at the time, there were 8 states whose state plans did not adopt the electronic record-keeping rule by the deadline set by FedOSHA. And California was one of those. The others included Washington, Maryland, South Carolina, Wyoming, Utah, Minnesota, and Vermont. Vermont has since adopted the electronic record-keeping, but as of today, now past 2 deadlines to submit the data, California and these 6 other states here on the slide have not yet adopted the rule. The first year, in 2017, when the deadlines were coming up, OSHA acknowledged that the state plans that had not yet adopted the rule, employers in those states did not have to submit their injury and illness data. In fact, the electronic portal where employers would submit the data would not allow you to enter data for a state in one of these 8 states that had not adopted the rule. There's, you're entering the data about your establishment, and if that was one of the states, it basically dropped out and said you can't, no data could be accepted on the site. Things changed a little bit in spring 2018. So just a few months ago, OSHA issued a press release instructing state plan employers to submit the data into the OSHA electronic portal, even if they are in a state plan that has not yet adopted the rule. And they referenced some, statutory provisions and things like that, supposedly giving OSHA the authority to mandate that these states, including California, employers there submit the data, even though their state plans had not adopted the rule yet. The various states, these 7 states that are listed here on the screen, replied to this press release in different ways. Washington OSHA and Maryland OSHA and Wyoming and a couple others basically stood defiant and said, hey, employers in our state, you are still not required to submit your data. We have not adopted the rule yet, and OSHA can't make you do anything. Cal OSHA sat somewhere kind of in the middle and advised employers to submit their 300A data on OSHA's portal. They did not mandate it. They did not say they were going to enforce it, but they advised that employers do it. My view of this tension is that OSHA absolutely does not have the authority to mandate that employers in state plan states take any action. OSHA, without question, has authority over state plan states, over the state plans themselves, and that authority resides in the fact that they can approve and rescind the approval of the charter to operate a state plan. So Cal OSHA operates with a substantial amount of its budget comes from OSHA, and it operates with the approval of OSHA. And OSHA can withdraw that approval if they don't believe Cal OSHA is operating effectively. But unless or until OSHA actually withdraws that approval, they can't insert themselves and dictate what employers in that state do. They have no jurisdiction over employers in that state. OSHA can't open an inspection of an employer in that state. They can't issue a citation to an employer in California because they have no authority to do that unless or until they rescind Cal OSHA's approved status. On the flip side of that coin, I don't believe Cal OSHA can enforce the electronic record-keeping rule because they don't have an electronic record-keeping rule. Cal OSHA would have to cite to a regulatory provision in a citation for failing to take some action, and there is no regulatory provision in California that requires employers in California to do that. So the deadline has passed, so maybe this is an academic debate at this point. Maybe we'll be having the same debate in 2019. I doubt it. But if we are, my view is, and advice that I gave to clients of mine in California, was that you don't have a regulatory requirement to do this. There should not be regulatory risk for not doing it. And by the way, OSHA has said that the main reason, that the main use they're going to put to this data is for enforcement targeting purposes. So if you're not required to submit the data, OSHA is going to use it for enforcement purposes. I recommend against submitting the data. So I don't know if folks out there in California did or did not do that. I know that many did. Talking to my friends at OSHA, that there has been data submitted from California. I don't know what percentage of folks did that, but my view is it's not a regulatory requirement until Cal OSHA makes it a regulatory requirement, or OSHA takes away Cal OSHA's approved status. So the reason why Cal OSHA has not adopted this rule yet, and I'm speculating a little bit, but it seems kind of obvious, is that OSHA has announced a bunch of times that they are about to issue a notice of proposed rulemaking, and they've been about to issue this notice of proposed rulemaking for over a year now, but they're about to issue a notice of proposed rulemaking to reconsider, revise, or remove or amend provisions of the electronic record-keeping rule. And so if the states are required to adopt it, and OSHA is about to change it or maybe even throw it in the trash, OSHA has decided that they're not going to, expend the resources, the legislative and agency resources to promulgate a rule that they will then have to turn around and change again as soon as OSHA decides what they are going to do with their rule. Seems perfectly reasonable to me. This is a situation that OSHA has created itself, that hopefully OSHA will resolve by telling the world what its plans are with the electronic record-keeping rule. So my bullet here in the middle, the most likely changes we're going to see to OSHA's electronic record-keeping rule, I have extremely high confidence in the first item. I would say with almost certainty that if there are no other changes at all to the rule, they are going to change that the large employers only have to submit 300A data. In other words, all employers have to submit only 300A data regardless of the size of the employer. I have less confidence in the next two items that they may change who is a covered employer under the rule, either increasing the size thresholds or increasing what constitutes a high hazard industry. I've been encouraging the agency to consider those changes. I'm not optimistic at this point that those changes will be included in the proposed rule, but we'll have to wait and see. Another element that I had anticipated, but now I'm less confident in, is that they may use the proposed rule to eliminate some anti-retaliation provisions that had been worked into the rule. I think those provisions are duplicative and unnecessary, and it sounded like the agency agreed, but we'll see what they do in the proposed rule. My last prediction here, which I also have a medium degree of confidence in, is that OSHA, despite the tension that is going on now between OSHA and OSHA, that OSHA is going to wait until OSHA either finalizes its changes or at least proposes its changes before it adopts some version of the electronic record-keeping rule. So we may find ourselves having the same debate again in 2019, but until then, my advice to California employers has been, until California adopts this rule, there's no rule for you to comply with. So an interesting debate, one that we rarely see in OSHA circles. So I'm going to turn it over to Andrew now to talk about a couple of relatively new and brand new and potentially new OSHA rules and rulemaking processes.
Thanks, Eric. California has been quite aggressive in rulemaking in recent years. Just the last 2 years alone, we've seen a number of developments. One of the more significant new rules has been around workplace violence in the healthcare industry. Historically, we've had citations issued over workplace violence against employers under the General Duty Clause of OSHA or under the Injury and Illness Prevention Program standard under OSHA, which is in a way a more aggressive equivalent of the General Duty Clause under OSHA. So there has been a need for employers from a OSHA perspective to address workplace safety issues. Now, many employers have injury and illness prevention programs that address workplace violence. OSHA now has required for healthcare a very specific plan. And to start off with, this healthcare standard applies only to home healthcare, emergency medical services and transport, drug treatment programs, and then they have a catch-all that is any health facilities, and that's essentially any facility that provides diagnosis, care, prevention, or treatment of human illness and requires a 24-hour stay or longer. It's been uncertain how broad this should be construed. There has been some guidance by OSHA on their website indicating that, for example, skilled nursing would be subject to this rule, but assisted living would not. So this has been an evolving question, but essentially any covered healthcare entity must comply with a number of different requirements. And many of you are not in the healthcare industry, but I think it's worth noting these issues because there is, as I will cover next, a general industry standard that's being proposed by OSHA. And I would predict that in the next couple of years that we will see a standard for workplace violence that applies to almost all employers. But under the healthcare rule, there's several different requirements. One is that the employer maintain a violent incident log, and essentially that records any incident of workplace violence, details of the incident. And then the employer must also train on the workplace violence prevention plan of the supervisors and employees, must also train employees on how to recognize the potential for violence, strategies to avoid harm. It's worth noting that this training must be tailored to the issues in that particular workplace, and there must be an opportunity for questions and answers by someone knowledgeable of the employer's plan, so it has to be a customized training in many respects. And there's a number of different requirements for creating a comprehensive plan document. And so by last April, healthcare employers were required to have this comprehensive plan, and we've worked with clients on creating these types of plans, and they're required to identify a number of different elements. And if you're working on your plan, my recommendation sincerely is that you ensure that that plan contains all of the program elements that are enumerated in the regulation, and that ideally you follow the format of the regulation, so when OSHA comes in and they do their own check-the-box exercise to see if you have a compliant plan, they can more readily just confirm, yes, it complies. But in a nutshell, you are required to have a plan that identifies procedures for obtaining active involvement of employees and their representatives in developing the plan. You need to have different procedures for obtaining assistance from applicable law enforcement agencies for workplace violence incidents. You must also have procedures for the employer to accept and respond to reports of workplace violence. There's the requirement that you have a process to ensure that your employees and supervisors comply with these requirements, and that includes both training the employees as well as having proper disciplinary procedures for employees that do not comply. And then you need to have an evaluation or an assessment of the workplace to identify factors, environmental risk factors, as well as patient-specific risk factors. And so this is something very unique to the healthcare context, where you're looking at patient risk factors, which really relates to any factors involving your patients that are likely to increase the likelihood of severity of workplace violence. And that could include situations where you have a patient or resident with that might have a situation of substance abuse or dementia, or any kind of ailment that could present a workplace violence risk. And then you also must look at the environmental risk factors, and that's really key to looking at the facility specifically and what the components of the facility are to the extent that they could create a likelihood or severity of workplace violence. And so there you're looking at whether you have adequate lighting in your parking lot, for example, whether you have a compartmentalized workspace where you don't have clear lines of sight, and another employee or supervisor might not be able to see a workplace violence incident as it's occurring, things of that nature. So what's important here is if you are a covered healthcare employer, you must make sure you have this written plan. And I can guarantee that if you have an audit by Cal OSHA, it's the first thing that they're going to ask for from you, given the nature of your business. And then you need to make sure, in addition to having the plan, you conduct the required training, as well as maintaining those violent incident logs. But what I wanted to do was transition over to the rulemaking related to the general industry standard. And so we don't need to go into a lot of detail here. This rule is in the works. It is evolving. From what I can see is this rule does address very similar circumstances as the healthcare workplace violence rule and has very similar components. What is important to note for both the healthcare rule and this proposed general industry rule is that you're really looking at workplace violence from various different angles. You're looking at violence that can be committed by a third party that may come onto the workplace with or without permission. You could be looking at a customer, a client, patients, and other visitors that have the potential for committing workplace violence. You're also looking at present and former employees and members of the general public. So you're looking at all of these different scenarios. And so my recommendation is if you have this rule, the standard addressed under your injury and illness prevention plan, or under a healthcare workplace violence plan, or in the future after the general industry rule takes effect, you want to address all the different ramifications or all the different scenarios of workplace violence and how they directly impact and are applicable to your workplace. This general industry standard, at least its present iteration, applies to essentially all employers in the state. They've carved out very few exceptions essentially for law enforcement agencies, Department of Corrections and Rehab, and we'll have more information about this rule in the coming months. I would expect it would take effect in the next year or two. And so we don't really need to go through, given the lack of time we have today, all of the different components, but as you can see, many of them are similar, or most are substantially similar to the healthcare workplace violence rule. All right, so now I will turn it over to Eric again to discuss indoor heat illness prevention.
So the one thing I would add sort of about workplace violence that applies exactly the same in the heat illness context, and there's a couple of questions about this, is, all right, if I'm in a general industry category right now, until this rule is promulgated, you know, how much risk is there to me as an employer, say, of an operator of a convenience store, which has been historically, in the OSHA context, an industry that has been targeted by OSHA in the workplace violence context. How much risk is there to me in California because there is no rule? Will California be similarly looking at a general duty type approach to these industries until a rule is promulgated? The answer is the same from a heat illness standpoint for indoor workplaces as it is for workplace violence in general industry. Cal OSHA has long had and has long enforced very aggressively its injury and illness prevention plan rule, which is, I would say, an even more useful tool than OSHA's general duty clause. It is the most frequently cited standard in Cal OSHA's catalog, and it basically allows them to say, look, as an employer, you've got to identify all of the hazards present in your workplace and address them. And so if workplace violence is a risk in your workplace, even if you're not a healthcare provider or healthcare facility, if it is a recognized risk or a risk that you reasonably should have been able to identify in your workplace, and convenience stores is one where there's guidance out there from OSHA and others about this unique risk there because people work late nights, alone, selling alcohol. You know, there's lots of statistics about robberies and risks of violence in those workplaces. Cal OSHA, just like OSHA, is going to say, well, you reasonably should have detected that risk and that should have been part of your injury and illness prevention plan. And under your injury and illness prevention plan, you should have implemented a variety of administrative and engineering controls to address that risk. And Cal OSHA, like Fed OSHA, usually works backwards and says, hey, there's been an incident, a robbery occurred and one of your employees was shot. We're going to work backwards and say that means your I2P2 didn't work effectively. Either you didn't identify the risk factor or the controls that you identified to address them were not effective. So the idea that Andrew is talking about a future rule for general industry should not allow you to sleep so well at night that you're off the hook from a Cal OSHA perspective, because they absolutely will and have used their I2P2 rule to enforce workplace violence and heat illness issues that I'm going to talk about right now in California. So talk a little bit about a rulemaking that is underway for heat illness prevention for indoor workplaces, and the place to start there is our relatively recent but beloved standard in California for heat illness prevention for outdoor workplaces. Right now there's an existing rule that was promulgated pursuant to a legislative demand, SB 1167. The existing rule applies to all outdoor places of employment, and basically if you have a risk of working at elevated heat and some additional requirements, if that elevated heat is particularly at 95 degrees Fahrenheit or higher, then you must implement a written heat illness prevention plan, a heat illness prevention program. That complies with specific provisions of this rule. The provisions include having the written program, implementing training for employees and supervisors in recognizing the symptoms and understanding the risk factors that would relate to heat illness, and then specifically providing and encouraging employees. And I've had cases where it seems like Cal OSHA's expectation is not only that you're encouraging employees to drink water, but that you're literally force-feeding them water. Seems to be the way the agency views this rule. And then providing access to shade and encouraging employees, and I would say more than encouraging the way the agency has enforced this, requiring employees to take cool-down recovery breaks periodically during the work shift. That's the current framework for outdoor employment, and we've seen Cal OSHA try to break down that barrier to indoor workplaces, either misapplying their heat illness rule or just saying, fine, we'll use the I2P2, and we've seen the appeals board affirm violations using I2P2 for indoor heat illness. But in any event, the agency has been trying to promulgate an indoor heat illness rule with not very effectively. So Governor Brown in 2016, utilizing the same legislative provision, basically mandated that by January of next year, so in the next 5 months, Cal OSHA is required to submit to the Cal OSHA Standards Board a heat illness rule for indoor places of employment. Cal OSHA is actively working on this to be ready to meet that January 1st, 2019 deadline. They have already published a couple of discussion drafts and held a couple of advisory meetings about the discussion drafts to advance and get closer to finalizing a rule on indoor heat illness. The discussion drafts that we've seen would apply to all indoor work areas where temperatures can reach 80 degrees Fahrenheit, and the rule is likely to look pretty similar to the outdoor heat illness rule in that it will require employers to develop a written heat illness prevention plan, that you will be evaluating heat stress risk factors, that it will require rest and hydration, that it will require you to have a plan for first aid and emergency response related to this heat illness risk, and that you make plans for acclimatization for an employee who is not accustomed to working in high heat, that you need to have a plan to identify symptoms associated with that and time to acclimatize to that higher temperature work area. One area that's a little bit different that has been in the discussion drafts and has been bandied about by Cal OSHA is the possibility of having exposure limits. In other words, limits of periods of time that an employee can be required to work in these high heat areas, and certain control measures that go along with that, including possibly some differences in how you handle employees based on the type of work clothing that they have to wear in areas of high temperature. So in other words, if it's high temperature and they're required to wear, flame retardant clothing or other, long sleeve or, other heavy industrial PPE or things like that, that the rules may be different and there may be limits for how long employees can be asked to work in there. And then, of course, training and tracking of heat illness incidents would be a similar requirement to the outdoor rule. A couple of challenges that we've seen in the rulemaking process where the agency is getting a lot of pushback and seems to be struggling with how to write the rule right here. How do we define an indoor workplace? And in particular, an area that they're having some trouble with is defining when vehicles or other, powered industrial equipment, things like that, whether those are considered indoor or outdoor places of employment. And that matters because the regulations are going to require different things for indoor, the indoor and outdoor rule will require different things, so it's important to be able to coherently define for employers what is an indoor workplace and what is an outdoor workplace, and then setting aside just whether vehicles and certain structures are indoor or outdoor. What about those workplaces, which is many, many, many of them, where employees work both indoor and outdoor? They transition from indoor to outdoor throughout a work shift. How do you manage that under a scheme that has different requirements for the same hazard, heat illness, or exposure to high heat, but you're working in both atmospheres throughout the day? So we're watching Cal OSHA struggle with that. If these are issues that are important to your business and you think could have a significant impact on you, we would encourage you to participate in this rulemaking process, and we can, of course, help you with that process. Calculating temperature. How is Cal OSHA going to, the rule applies based on certain temperatures being achieved. How do you measure that temperature? Do you factor in humidity? Is it the heat index, or is it the dry bulb temperature? And right now the latest draft talks about a dry bulb temperature reading, which I think would be the easiest and the best. You measure the air temperature using a thermometer freely exposed to air without considering humidity or radiant heat, but we'll see where the agency lands on that with a proposed rule. And then addressing work clothing. The rule, as I said, has dabbled with possible requirements related to work clothing. Be interesting to see how that evolves. All right, coming down the home stretch here, I'm going to hand it over to Andrew to talk about, I think, the most new, the brand new rule regarding Cal OSHA's ergonomics rule for hotel housekeepers.
All right. If you are a hotel or a lodging establishment, you may have had a moment of panic over the last month thinking about this new rule and how you're going to comply. It has had a pretty short timeline for compliance, and the requirement essentially applies to, this is a new standard for hotel housekeeping, and it's a mouthful. It's called the Musculoskeletal Injury Illness Prevention Program. I will refer to it as MIP for short. And the MIP standard applies essentially to any hotel or lodging establishment that has housekeeping. And the focus is really on the ergonomic hazards associated. Let's move to the next slide. It's focused on the ergonomic hazards associated with the tasks of hospitality housekeepers. The rule went into effect July 1st. So as of July 1st, you are required, if you, as a covered employer, to have a MIP plan document. And then you are required to conduct a work site evaluation for any ergonomic hazards for housekeeping by October 1st. So you still have time for the worksite evaluation, but you need to finalize and implement that MIP program. And the obligation is not just to develop the written plan, but also to maintain and implement it. So just in terms of coverage, it applies to any lodging establishment. The focus is really on anyone. The person does not have to have the title of housekeeper, but has to perform some sort of housekeeping duties that are associated with the cleaning of lodging rooms. And you're required to have this MIP program plan that addresses a number of different factors and has different considerations here. The plan must, and I'll go through some of the highlights here. This is a much longer discussion, possibly for another webinar, but you're required to, like, for example, the healthcare workplace violence rule, you're required to ensure compliance by employees. You're required to ensure communication with employees. In this context, you need to communicate the expectations and the plan to your housekeeping staff. You also need to have procedures for conducting work-safe evaluation. There's a workplace evaluation that's required to be completed within that 90-day period after this plan takes effect. You're also required to investigate musculoskeletal injuries and take appropriate corrective action. You're required, in terms of the worksite evaluations, you're required to update those as necessary based on injuries and other observations. You have the worksite evaluation, as I mentioned, and you have to have an annual review of the MIP document for effectiveness. And one common theme for this plan is that you are required to seek input in numerous respects from housekeeping staff and from their union, if there is one. And what I recommend, and we've developed a number of MIP programs for clients, and what we've done is we have developed a comprehensive plan that's user-friendly, that tracks the standard, so it can be readily verified by a OSHA inspector that the property has complied. But also what I think is helpful is to have various forms that can be used that have all the proper fields to ensure that you're doing what you need to do consistent with the standard. And that is, for example, if you're conducting an investigation of an injury, that you're going to have reflected on that form that you've looked at corrective actions that can be taken and control measures that are in place. There's a number of different variables, but you want to, if you can have some of those forms, the investigation form, the worksite evaluation form, potentially a maintenance request form, other ones that can just make it a little bit easier for you to comply. There is a training requirement here as well. And you're required to have a training specific to the MIP document. You need to also provide sort of a practice training for housekeepers on how to use different equipment to ensure that they're complying with the ergonomic standard.
If I could, before we move on to the next topic, if I could just raise one little alarm bell here. Just as we've talked about with workplace violence and with heat illness, where Cal OSHA does not have a specific rule for your industry, they use the I2P2 rule to enforce similar requirements. So this is a very narrow, specific requirement for lodging establishments. And so you might think, all right, I can tune out. I don't need to listen to Andrew because I operate, a manufacturing facility or a car dealership or whatever. The reality is, as Cal OSHA becomes a little bit more adept at evaluating musculoskeletal risk factors and hazards and starts getting comfortable citing employers under this new standard for hotel housekeepers, they're going to start to jump over to those other industries and say, all right, let's use our I2P2 rule and say, are you doing enough in the manufacturing space to identify musculoskeletal risk factors and implementing, administrative and engineering controls to address them? So I would say that this is a forecast to what Cal OSHA is going to expect across all industries. And the reality is musculoskeletal injuries is the elephant in the room. That's by a large measure, the most significant workplace injury that occurs across all industries across the country. And there has not been a coherent plan at the Fed OSHA level at Cal OSHA or any other state plan, I shouldn't say any other because some do have ergonomics requirements, but there has not been a coherent plan for how to regulate that risk that is the biggest risk in workplaces in this country. And so here is Cal OSHA dipping its toe into a particular industry, and my expectation is that you're going to see either copycat type rules for other industries in Cal OSHA. All of a sudden there's going to be a MIP requirement for manufacturing or other industries, or they're just going to take their sort of institutional learning about how to enforce this hazard against hotels and say, we're now going to start enforcing this under I-2P2 for other industries. So I think everybody needs to pay attention to what's happening here with this hotel housekeeper rule, even if you're not in that space. And so now I think we will move on to that last proposed rule here, and Megan's going to take us home talking about marijuana and cannabis.
Okay, so in the cannabis industry, there is no industry-specific proposed rule at this time, but they have gone through a couple iterations of rulemaking. They were originally, Cal OSHA was originally required to convene an advisory committee and evaluate whether industry-specific regulations were needed for cannabis facilities. And through the first process of meeting with the public and talking about various issues, various risks were identified, but they ultimately decided that workplace hazards in the cannabis industry were adequately addressed by existing regulations, so there was no need for industry-specific regulations. However, they have reconvened in January of this year. They had a second advisory committee to revisit this, wondering if these regulations are adequate or if they do need specifics. The topics that came up specifically are employee exposure to secondhand smoke on sites where use is permitted. Additional concerns that have been raised is risk of combustion from the process of preparing various products, inhalation, workplace violence, specifically armed robberies, and repetitive strain injuries. So they are required to present findings by October of this year, at which time the board is to render a decision. So we are in a wait-and-see period. We're already 6 months into the second evaluation period, and it will remain to be seen what, if any, industry-specific regulations come out of this second evaluation process.
Eric, did you want to answer some questions?
Oh, sorry. Yeah, I was on mute there. That brought us to a couple of announcements, and then we'll address some of the questions that I've seen come in here. The first is, you're with us right now for the 7th webinar in the 2018 OSHA webinar series. I hope that you find some of these other topics the rest of the way interesting and that you'll join us for those. Just shoot us an email and we'll get you registered for all of the rest or any individual programs you want to join us for. We have recorded today's program as well as all the prior programs this year and for the last 3 years, and so that we have an archive of those recordings. If you're interested in those, there will be a link to that archive in the follow-up email we send after this program. So I hope you do join us for the rest of the programs. I'd also encourage you to check out our OSHA blog as well as our labor and employment blog, the OSHA Defense Report or the Employer Defense Report, and a lot of great content on there. We work really hard to keep that fresh, and I'd love to know that someone other than my mother is out there reading it, so please check that out. And then also, if you are in the process safety industry, chemical manufacturing, petroleum refining, or any industry that intersects with process safety or risk management, regulatory requirements. Please join us in Washington, D.C. in person in October for the inaugural Process Safety Summit. We're putting together an absolutely fantastic program with speakers from the senior leadership at OSHA, EPA, the Chemical Safety Board, some of the trade groups most actively involved in process safety. It's going to be a terrific program there for sure. And then finally, let's dive in and tackle some of the questions that we've seen come in over the course of the program. The first question that I see is about the adoption of the penalty increases. The question is, what was the deadline for the state plans to adopt the increase in dollar penalties? It looks like from my research that when OSHA adopted the first, by its own rulemaking process, adopted the first big penalty catch-up, they included a provision, and that was in the very beginning of 2017. They included a provision that said the states must do this within 6 months, and it looks like OSHA did adopt this rule. I'm not sure when the penalties went into effect, but they adopted the rule in July of 2017, so they were more or less in line with the 6-month window that OSHA set for the states. The reality is OSHA does this all the time. We talked about the e-record keeping rule, right? They said, states, you must adopt this rule within 6 months, but the reality is a lot of the state OSH plans can't do that, right? They have their own rulemaking or legislative process that they have to follow to promulgate new rules, right? They are an independent sovereign government, and they have to go through the same process that OSHA goes through, and OSHA rulemaking can take 12 or 13 years, and they say, hey, in 6 months, adopt a rule. So it's not easy for the states to do that, and that's why you run into this sort of tension like we're seeing with the e-record keeping rule. But it does look like for the civil penalties that California adopted that pretty quickly after OSHA made the mandate. Some of their penalties were already higher than OSHA, so it was a hodgepodge of what was actually increased. A really, really great question here from one of our audience, and I won't identify the company name, but the question is about the new repeat rule in California. This is a sort of very significant company that has either a lot of different divisions or a lot of different subsidiary companies that operate in different spaces, but many different facilities in California. So if I've got a food manufacturing company and a trucking company and a distribution company and all of these different products and services in California, is there now exposure to all of those business lines to a repeat violation all over the state of California based on a violation at any one of them? Well, the answer is it depends on the corporate structure of that entity. If those are business lines, in other words, it's a division of a single corporation, then there is risk that OSHA will go across those business units and cite repeat violations. If those are in fact separate companies, separately incorporated, and the corporate form is respected, then they should not be at risk for repeat violations from sister company violations. The evaluation is the substantially similar violation has to be committed by the same employer, and the same employer has to be the same entity. So if you are operating as separate corporate entities and you're truly separate, not commingling funds, not too much commingling of management, then you should be treated as separate employers by OSHA, and there wouldn't be risk. But if you are just a different division, operating division of one employer, then there is risk now that OSHA will go across all of those different business lines to cite repeat violations based on a precedent violation by one of your sister facilities in a totally different business line. Now, you may generate arguments and defenses that, hey, this is not substantially similar because we're working with different kinds of equipment, different operations, but at the end of the day, the main focus is going to be on what is the hazard, what is the standard, and how substantially similar are the circumstances. So you can have a guarding violation on a saw at your grocery store and at your warehouse and at your distribution center, but it's guarding a saw. It's the same hazard, same general use of that tool, so you can see the repeats run that direction. Let's see, a really good question here that I'm gonna take a guess at this, and I'll actually I'll ask Andrew what he thinks about this as well. The question is, would the musculoskeletal injury prevention plan requirements for what we've been calling the hotel housekeeping ergonomic standard, but it's really the lodging housekeeping activity ergonomics rule, does that NIPP requirement kick in for housekeepers working within the Airbnb context? And that's a terrific question. I'm just going to go back and read to you the definition of lodging establishment and give you my best guess at this. We'd have to research this a little bit closer. But a lodging establishment is an establishment that contains sleeping room accommodations that are rented or otherwise provided to the public, such as hotels, motels, resorts, and bed and breakfasts. So I would say an Airbnb is an establishment that contains sleeping accommodations that are rented or otherwise provided to the public for rent. So first step of the equation is, it sure sounds like an Airbnb setup would be a lodging establishment. The second element, though, is that person that's cleaning the Airbnb your employee? And this would invoke an analysis under basically the independent contractor. Is this an independent contractor or an employee? I would say if there is a separate contracting entity that is managing the housekeeping across a bunch of Airbnbs, that's the employer that has to develop the MIPP, as opposed to the homeowner who's utilizing or taking advantage of this Airbnb platform. But if you are determined to be the employer for someone who is cleaning lodging establishments, then I think the rule would apply in that context. The question then would become, who is the employer that's subject to these requirements? So really interesting question. If that's something that you need us to look into a little bit deeper, happy to do that. And I would welcome any input from Andrew or Megan about that. That's just my, from the seat of my pants, guess there.
Eric, I was thinking the exact same thing. Based on the definition of lodging establishment, it would appear that the Airbnb context would apply, but they do have some exceptions for as an example, hospitals, and I think they also exclude prisons. But and there's nothing that would suggest that an Airbnb type rental would be exempted. And I also agree with you, Eric, about the independent contractor issue, and that if you have the housekeeping provided through Airbnb, that could be seen as an independent contractor arrangement, but that's a much more complex issue about joint employer and what sort of control you would have over that housekeeper.
Yeah, right. So last question I see here is about the electronic record keeping rule that somebody on someone else's advice did submit electronic data for California establishments to the Fed OSHA web portal for the 2017 data submitted here in 2018. And the question is, if I had not done that, was there some other mechanism or some other way that Cal OSHA would have accessed, or I would have been required to submit to Cal OSHA in some other form this 300A data? And the answer is no, right? This injury and illness record well, I shouldn't say no. The only way that the agencies, whether it's Cal OSHA, Fed OSHA, or whoever, historically accessed your injury and illness record keeping data was through an active enforcement inspection, right? They come in, they have subpoena authority, and one of the first documents they always ask for are your 300 records. And so if you have an active enforcement inspection, they're going to get probably 3 or 5 years worth of injury and illness data, including the 300A data. Otherwise, unless you are asked to participate in the Bureau of Labor Statistics survey or some other OSHA injury data survey, this data has been private. It has been for the employer. It's posted for about 3 months every year on a bulletin board in the workplace. The 300A is for your employers to observe, and then it gets tucked away in a file cabinet in your safety department or your HR department, and it is not something that is shared publicly with anybody. A union can ask for it, a union representing employees at that workplace can ask for it, employees can ask for it, and the agency can ask for it during an inspection, but otherwise it's private data. That's the big difference with this rule now, is that we're proactively sharing it with a regulator. And FedOSHA has the right to demand that data, has demanded that data from employers under FedOSHA's jurisdiction. Cal-OSHA hasn't adopted the rule, so right now California employers' injury data continues to be essentially private data, unless or until California adopts that rule. So that's why, from my perspective, I look at the reporting rule, right? There are certain injuries that have to be reported. You pick up the phone and you call Cal-OSHA when there's been certain serious injuries that occur, hospitalizations, whatever. You're not going to pick up the phone and call Cal-OSHA if you have an injury that doesn't meet those criteria. Well, it's a relatively serious injury, and as a courtesy, I'm going to call Cal-OSHA and tell them that this happened. I view this circumstance the same way. I don't have a regulatory requirement to share this data with Cal-OSHA. Why am I going to do it, knowing that they're going to use it for enforcement purposes? So that's my view of that. I may be proven wrong. I hope not, for anybody that I advised not to submit the data, but I'm pretty confident that there's not a regulatory requirement in California right now, and there's not regulatory risk. But this has been a fun subject to dive into for sure. So again, I want to thank everybody for joining us, and particularly want to thank Andrew and Megan out in California for putting in a lot of hard work to get this program ready, and welcome once again Megan to our firm. She's already proven to be a terrific addition, helping us with this webinar just 2 days into her tenure with Conn. So those of you out there with Cal-OSHA issues, our bench is growing and our experience with this agency is strong, and we would love to be a resource for you. So here's 3 people you can call anytime with Cal-OSHA related questions or any kind of OSHA related questions. And we do hope you join us again for future webinars. Thanks, everybody.